intellectual property attorney. I'm also acutely aware that I'm standing between you and lunch. I'm also acutely aware that you just had to listen to 3 separate talks on IP. I know Donal talked about kind of the fundamentals based of IP and how you should be looking after that. And Aaron has obviously highlighted there some of the issues that can, and one of the major issues that can happen with IP. And I want to talk to you today about some of the perils and the pitfalls that you might have in managing your IP. So we're an intellectual property firm. We represent all types of inventors. We go from individual inventors like orthopedic surgeons up to SMEs, right up to multinational pharmaceutical and healthcare companies. So we run in this sector and we have seen a lot of things, and we've seen a lot of things go wrong. So I want to highlight some of the things that we have seen and how you might be able to save yourself from things going wrong. Everyone has an idea about intellectual property, particularly these 4 main areas of patents, trademarks, copyrights and design. Donal talked about it earlier on. Another thing that was touched on and you should be aware of is that there's all types of intellectual property, so don't just rely on your registered intellectual property. Remember, there's all different types, and you might have intellectual property in whatever type of research you're doing, in confidentiality or in database rights and things like that. Certainly, it's a tightrope. Working with intellectual property is tough. There are a lot of pitfalls, and I know a lot of people feel like this every day when they're managing it. It's very, very easy to get into trouble, and it's very, very difficult to get out of trouble with IP. So hopefully we can go through a few of the things that we've seen happen before and give you ways to avoid them. One of the main pitfalls we see with people is overlooking intellectual property in your business or in the research that you're doing. A lot of people say, I don't have any IP, I don't generate IP in the type of things that I do. If you're generating ideas, if you're doing research, you're generating IP. So overlooking it is a really, really simple thing to do, but it's a very, very common thing to happen. So when we're looking at, in this sector, when we're looking at in healthcare, the type of things that people are doing, we do a lot of med devs, a lot of med tech, but remember that that one device, for example, could be covered by all different types of intellectual property. So we do work on inhalers and the shape of inhalers, and that will be covered by design rights. So that's the outward look, and I was talking earlier on. So the outward look of the inhaler can be protected. We do a lot of work with people who are developing apps in healthcare. So Fitbit's hot right now. There's a lot of that kind of thing going on. This can be protected by copyright, by patents. Trademarks. Medtronics is the biggest, the highest grossing value trademark in Ireland at the moment. So don't forget that trademarks, especially if you're working in a B2B situation, are very, very important in this sector. And finally, of course, patents. I think everyone kind of always associates patents with this type of technology. But remember, whatever type of technology you're working on, as long as you're generating ideas, you're generating IP, and there are a number of ways to protect it. So don't overlook and think that you might not have any, or there might not be ways to protect it. So always, always, always look at the research you're doing. Talk to your technology transfer person if you have one. You may be it if you're a sole inventor. And check that you're always keeping an eye on what type of research you're doing and what type of results you're getting. Huge thing that people do is neglect the registration process. A lot of the time it's expensive, people don't want to go down that route for cost, for time, for the effort, and it is possible to do. So you can rely on your unregistered rights, but it's not as easy to do. The main thing is that if you register your rights, you can avoid having to prove copying. Okay, so registering your rights means that you won't have to prove that somebody was copying you. It's an exclusive right, so you can just like Aaron said, you can go into court, you can take your registered right and say, this is my registered right, and you don't have to prove they were copying as long as they are doing whatever you're doing. If you have an unregistered right, you have to prove that they were copying you, that they actually got hold of your research or your ideas or your results, and that they tried to copy them. So do try and register as much intellectual property as you can. It's not for everyone. You should definitely talk to your intellectual property attorney to check you know, is registration the right route for you for the type of work that you're doing, or what parts of your inventions or research might be registrable. This is a big one. I think everyone sees this. I think the Patent Office see it a lot, Marion see it a lot. So coming to register IP too late, or at least to assess IP too late. This happens a lot. People don't think there's IP, they go out, they go to market, they launch, they talk to investors, they talk to partners, and quite often it's too late to go back and check on your IP. So I urge you to take a stand on IP early, at least assess it early, and at least you know where you stand. If you do not do it early, certain rights can be invalidated. Okay? So if you go out and publish your work, if you talk to partners, if you go out into investment streams, in any way publicise your work before you apply for registration of your IP, you can invalidate that IP. This is particularly important in the aspect of patents and designs. So I know everyone wants to get there, everyone wants to get to market, everyone wants to get their product out there, everyone wants to talk to investors to get them on board. If you do that without assessing your IP and taking the necessary steps for registration, you could invalidate it. So I urge you to talk to someone before you do it, whether it be an intellectual property attorney or somebody in tech transfer in your organisation, or the patents office, but it's very, very important to do it. So make sure before you make any sort of publication that you talk to someone that can tell you what you can and can't do, or what you should or shouldn't do before you go out. This happens quite a lot as well, conceding ownership of intellectual property. Everyone will talk about intellectual property and what it's worth to your business or what it's worth to you, and it's an intangible asset that you can use. And it's an intangible asset that forms part of your business, and it's very, very valuable. It's only valuable to you if you own it. Okay? And very, very often people are generating IP and they are conceding the ownership to other people. If you take in consultants, that you don't necessarily own any IP on the work that they do for you. If you take any sort of commissioned work in, you don't necessarily own the IP that they do for you. Okay, so if you consult out, if you have designers in, if you have outside research, if you go to external source for research, that IP may not vest with you or your company. So it's very, very important before the outset that you understand who owns what IP in these situations. Some of these things are governed by law, some of them are governed by contract, some of them are governed by a combination of the two. So it's very, very important that before you start external work with anyone, that everyone understands where the IP vests. For you, you want it to vest with you or your company, obviously. And it's very, very quick for people to give up on it and to enter into research collaborations, to enter into VCs, to enter into JVs, and for IP to leak out of the company very, very quickly, or to leak away from you. So be very, very careful about ownership. Make sure everyone knows who owns what, and most importantly, make sure you own it all. Otherwise, you could be looking at somebody else getting hold of your IP. So always, always, always consider, are you going to own something? If you're going to engage with someone else, are they going to own something? It can leak very quickly, and once it's gone, it's gone. It's very hard to get back, okay? Or it's very expensive to get back. Either way, it's not good. One of the other issues that we really see a lot is neglecting commercialization of IP. IP in itself is generally an exclusive right. It allows you to stop other people doing what you're doing, it allows you to stop other people copying what you're doing, but it in itself won't generate you money. An exclusive right doesn't make money, it allows you to stop other people making money off you. Okay? So you can go to the time, you can go to the expense of securing all this IP, registering all this IP, owning all this IP, but unless you do something with it, it's not going to make you money. It's going to sit there, and what it's going to do is actually going to cost you money. So if you're managing your IP correctly, you should really be commercializing it as much as possible. That's going out into the market, understanding that as an intangible asset and as a piece of property, the intellectual property is a piece of property that you can transact like any other piece of property. So you can sell it, lock, stock and barrel, that's assignment. You can let somebody use it for a fee, that's licensing it, okay? You can do all sorts of things. You can mortgage it, you can use it as a security interest on things. So remember, it is an intangible asset, but it in itself doesn't make you a lot of money. It forms part of the basis of your company and the value of your company, but it's not going to make you money. So you need to transact it. So always make sure that you're in a position where you're commercializing, actively commercializing your IP. And this is where you can go out and make some money for you. This is what Aaron was touching on earlier on. So many people go out into the market, whether you have IP or not, other people have IP. So when you go out into the market, be aware that other people have IP, and the point of their IP is to stop you doing what you're doing, and the way they'll do it is to bring you to court, and they'll try and sue you, like Aaron was talking about. So it's one of the pitfalls we often see with people is that it's neglected what other people, everyone wants to talk about their own IP, and people neglect what other people are doing with their IP, and remember that other people's IP that's out there is a barrier to you entering the market. It's stopping you doing what they're doing, and it's going to cost you a lot of money if they come after you for it. And like Aaron said, vexatious people will come after you, and that's you knowing that these people are going to come after you. So ignoring it will not help you. IP is not a license to do something, which is also very important. It's not letting you do it. So just because you have IP doesn't mean that you can go out and commercialize whatever you're doing, and it's not going to save you from somebody else having IP on that same product. Okay? So don't think that because you have IP you're allowed to go out and do whatever your IP covers. Okay? If somebody else has IP out there, they can stop you doing it. You can end up in all sorts of cross-eyed scenarios. But one of the huge misnomers that people have is that if I have IP in it, I can go out and use it. That is not the case. If other people have IP, they can stop you doing it, is the case. So always make sure that you check what kind of IP other people have out there before you enter the market. Certainly investors, VCs all want to know that you've made some sort of effort to understand what kind of IP is out there, so that you know that the road is clear ahead for commercialization, and anyone getting on board is not going to get in trouble. You'll see it all the time. One of the first questions that they'll ask on things like Dragon's Den is, what kind of IP have you got in place, and what kind of IP do other people have in place? Because they want to know that they're not investing in something that will completely be blocked from day one, or that's going to bring a lawsuit on top of them. That normally doesn't go very well in those sort of negotiations. We've worked very, very closely with KTI, Knowledge Transfer Ireland. They're the governing body for tech transfer, and we've put together this practical guide for managing IP. This will give you some idea, and it's focused on researchers and scientists, so anyone who is doing sort of research work, innovative work, and it'll tell you the type of IP that's out there. It'll tell you the type of IP that other people will have. It'll tell you how to commercialize it. It'll tell you how to interact with state bodies. It'll tell you how to interact with the industry if you are in a state body. It's available from the KTI website. You'll also get it from our website, which is frkelly.com. There's a lot of information in there, so if you have questions, it's definitely a lot of information that will answer some of your questions and will cover some of these pitfalls that we're talking about. Have a look at that. We're here today as well for the whole day. We're on stand 149, and you'll also get dedicated information at our website at frkelly.com. If you have questions, come and talk to us. We're here all day. I know in these sort of situations not everyone wants to put their hand up and ask a question out loud, because people have secret things that they don't want to publicise. So come and talk to us on the stand. But if you have any questions now, I'd be happy to answer anything you have now. But we're here all day. Thanks very much.
Thank you.